So guys, welcome everyone. Thanks for joining. I'm Chris Burdick with Rain City Capital of Oregon.
I'm Lesa with Rain City Capital of Washington.
And the class today is Structure for Success, how to structure your business and reduce risk.
Absolutely. That's right. We're going to deep dive into structuring your partnerships the right way. And here to help us is Shawn Morgan. I'm so excited.
So yeah, guys, Shawn is attorney for actually one of my clients and down here in the Oregon area. And Shawn does it all. So he'll do creation, formation of the LLCs and documentation there. He'll do, advising on landlord-tenant negotiations, whether it be entity formation or also like drafting up documents for, kind of off-market transactions. So everything in the legal space, Shawn has been doing for many years now. So yeah, I just want to say thank you to Shawn for making the time today and coming out.
Thank you, Chris. Thank you, Lesa. Looking forward to chatting with you guys today.
Absolutely. Just so we can put out how this is going to structure and how it's going to work, Chris and I are going to go back and forth and just like a Q&A with Shawn and just ask him lots of questions. We're going to deep dive into different partnerships. He's actually going to have a case study for us. He's going to analyze that. And at the very, very end, about 15 minutes, we're going to save that for Q&A. But don't be afraid to ask questions during our questions, just in the box. You'll see it, type it. We'll get to it. Greta and Madeline are here to make sure we get your questions answered. So let's do this.
Yeah, awesome. Well, we'll kick it off. Well, real quick before I jump on the first question is just to remind you guys, this class and this topic was born out of feedback you guys give us on our surveys. Those surveys are awesome for us to kind of figure out what you guys want to see in the next classes coming up. So we're giving the right kind of content that you guys want to hear more about. And so at the end of the class, we're going to do a survey again. And we strongly encourage you guys to fill that out, put your ideas and your thoughts on what you want to see in future classes. Always be bringing you the best content. Okay, that's that plug.
That is true, though. I'm glad that you said that because Chris and I have been doing this for almost a year. And every single class, we always ask, what do you guys want? Because we want to be a service to you. And we're in this together. So this class definitely came from you guys asking for it. And Shawn, thank you for coming on. So,
okay,
yeah, let's do this.
So Shawn, let's just jump in. Tell us a little bit about how you first got into real estate law.
Well, thanks to both of you and thanks to Rain City for having me and letting me talk about this exciting topic on this Thursday afternoon. But I have been practicing law for about 15 years. Started in Nevada. I was a prosecutor for 5 years there and moved up to Portland after kind of getting burned out on really the darker side of the practice of law in Las Vegas. You kind of saw a lot of things that, can't really unsee. So I moved up here looking for a transition in 2012. And I was originally going to pursue a restaurant business at the time and leave the law behind until I realized that there really wasn't a long-term retirement strategy there. So after kind of floating around for a little while, I saw a job posting for mortgage default servicing law firm. And at the time I had no idea what that was. And I showed up and it was actually representing banks doing foreclosures. And because I was able to manage a large caseload as a former prosecutor, they hired me on the spot and took me a little while to learn, but eventually was put in charge of making sure that the foreclosure process was done effectively and then getting the property sold. And then after, if the bank bought it back and there was problems, clearing clouds on title and basically fixing problems. Through that lens, I met a lot of investors, people that were buying the properties at auction. And it also opened my eyes to real estate as an investment mechanism myself. Through those connections in 2015, I went out on my own, opened my own practice and started building my own investment portfolio. And now here we are almost 7 years later. And my practice today is basically focused on representing investors, developers, and landlords with all aspects of their legal needs. So whether that's commercial or residential, I just help people find solutions to their real estate needs.
That's awesome.
That's awesome. I'm so glad. And you have 3 little kiddos, right? The human
Yeah.
element.
Yes. Yeah. As a
Yes.
person, I have a lovely wife. She's a nurse at St. Vincent.
Awesome.
And we have 3 young daughters. I got a 4-year-old girl and then twin 1-year-old girls. So I spend a lot of time juggling babies when I'm not, juggling cases. And just a quick disclaimer: I am licensed to practice in Nevada and Oregon as it relates to these conversations. I'm not licensed to practice law in Washington. And again, this is just kind of a general conversation about business entities and risk today. So
Absolutely. Well, let's dive right into that. Tell us the different kinds of partnerships and how they are structured.
yeah, so there's really, if you think about the different types of partnerships, it's more of an evolution of kind of case law, and they all kind of arise out of statutes. The first one is a general partnership. And that is an association of 2 or more people who carry on a business for profit. And that will be implied on 2 people that are basically working together, whether or not they intend to create a partnership. The issue with a general partnership is it creates joint and several liability for the partners for everything that the partnership does. Because of unintended consequences, then the law kind of created this thing called a limited liability partnership, which is available in Oregon. I'm sure there's a Washington counterpart that I'm not familiar with, but that is really applies to professionals. And so that would include accountants, architects, attorneys, chiropractors, landscape architects, and then real estate appraisers, not actually real estate investors, to my knowledge. And that limits your liability to things that basically, if you think of it like a conglomerate of doctors, if one doctor cuts off someone else's leg or performs a surgery on the wrong body part, they're going to be liable for what they did, but the other doctor in the group is not going to be liable in a limited liability partnership. So the next iteration is a limited partnership. And that makes a distinction between general partners and limited partners. And the general partners are the ones kind of doing the business of the day-to-day. The limited partners are the passive investors. And the kind of structure there is the general partner is going to be liable for everything the partnership does. The limited partner is going to only be liable up to the amount that they have contributed to the partnership. And then finally, now in like the 70s in Wyoming, the state of Wyoming decided to create a limited liability company. And a limited liability company is an entity that's an unincorporated association of 1 or more members. So instead of partners, you have members, and that it's the best of everything. It takes the limited liability of a corporation with the pass-through tax structure of a partnership and puts it together in this company. Also, in the context of real estate, there's also tenant in common agreements. If you're not going to pursue a partnership, you could also pursue a tenant in common agreement. And that is, just another good vehicle to arrange a partnership. So those are kind of the 5 big ones that you see.
So there's general partners, the general partnership, there's general partners with limited partners. There's an LLC, which is kind of the most common for us, frankly, in our business.
Yeah.
And then there's and then there's also limited partners, just limited partners by themselves. Did I get that?
Yeah, so there's 5: general partners, limited liability partnerships, limited partners, LLCs, and then tenant in commons. The limited liability partnerships you don't really see. The general partnerships you don't really see in the real estate context. Limited partnerships you see really only in the LIHTC, low income housing tax credit deals, where the nonprofit is the general partner, and then they sell the tax credit to the for-profit limited partner. And that's just how the IRS likes to see those deals structured. So that it's really the only time in real estate that you see a limited partnership, or that I have seen them show up. And then the main two are LLCs and tenant in common for the purposes of real estate.
Okay. Okay. So yeah, this kind of goes right in the question of like, when does each kind of partnership make sense, and does it matter which one you're using in those scenarios? Obviously, for us, we always see a bias towards the LLC. So yeah, I can kind of expand on that a little bit.
Yeah. So again, when you come talk to a lawyer, my job is to help you figure out how to minimize your personal risk, and doing that is going to be really through an LLC in the real estate context. That's going to be the thing that's most effective at ticking all the boxes and limiting liability.
Okay.
Right. That was kind of the question of like, what is the risk of each of them? Or what is the risk? Seems minimalist at the LLC, but is there still risk in that LLC?
Yeah, personal liability is the big risk, right? It's like we're creating these entities so that we can not have, if something goes wrong with your investment, you don't want to lose your home, or your personal assets. You want to try and keep it in the box of that particular investment. So the risk is that you don't do it right. So you've got a rental property. The example I always use is, you've got a rental property and you lease to a tenant who is cooking meth, and the rental explodes and blows up the house next door, killing a child, which isn't something that I'm
dark
making
real fast.
I know. Wow.
This isn't something I'm making up. This actually happened.
Oh my God.
So yeah. And
yeah.
That's what, like happened. When you talk about,
here.
Yeah, limiting liability is like this vague concept, but when you're actually trying to apply it to practical knowledge, it's not just like, okay, someone slips and falls, someone falls off a ladder. No, like the worst case scenario is actually that. So now you've got everyone who's upset and they're going to sue everyone. Your insurance is only going to cover so much. And the way to protect your assets is to make sure that you formed your LLC properly, such that they're not going after your own personal bank account. So that requires corporate formalities, right? It requires having a separate bank account. It requires having paper trails of things. It requires not paying your Netflix out of your business bank account, to make sure that these things actually have their own little existence. They're in the eyes of the law, an LLC is a person. So you wouldn't ask your neighbor to pay your Netflix account out of their bank account, and it's kind of, you think about it in the same vein. So that's the risk, right? Not doing it right, piercing the corporate veil. And then the other side of the other big risk to think about, especially in the state of Oregon, is it's very common for organizers of LLCs to go out and raise money, and how you're raising money can present securities issues, where if you're selling someone an interest in an LLC, it can easily be construed as a security. Which is why it's always great to go to someone like Rain City to get your financing needs, and not have to, ask your neighbors and your fellow citizens. And then if the deal doesn't go right, you end up getting sued, and the lawyer gets sued, and the accountant gets sued, and everyone gets sued, and it becomes a big mess. So securities and personal liability are the big risks, to answer your question directly.
Oh, that's awesome. That's exactly what we wanted to know. Yeah. We don't want to be personally responsible. Yes, totally get it. I hear you. I hope everybody heard that as well. So definitely.
Shawn, let me ask you a question, because I a lot of times I'll talk to borrowers. I'm sure Lesa does too, where they come in and they're just individuals. They don't have an LLC. It's just, maybe it's two people that just met, and they're they're partnering up. They don't have an LLC yet, or maybe they just want to do the deal as like individuals. What would you say to people about, how do they determine if a partnership is right for them?
Yeah, that's a good question. So frankly, it all goes down to your level of risk tolerance, right? You should talk to a lawyer. they'll present you the pros and cons, and then they'll likely punt and say, well, that's a business decision for you to decide on your own. You need to ask yourself, do I have substantial assets such like, if it's your first deal, I know plenty of people who, don't own their own home, or leasing a car, don't have a substantial sum of money in their bank account, and they're just kind of trying to put something together, and spending a sum of money on creating an LLC and having a separate bank account and having to do a separate QuickBooks account. It's just it's a whole extra set of steps that you have to follow. Frankly, I'm sure you guys can validate this. You're going to be getting a personal guarantee on any money that you lend.
Every loan.
So if your project doesn't work out the way you want it to, the bank is still going to be able to come after you individually. So you need to decide how much of having that extra entity is worth it for you. If you're in a different place in life and you've got a portfolio of investment properties and you've got retirement accounts and you've got kids and you're just at a different stage, then managing risk matters more. So it's just a personal decision, really.
So if you have things to lose, you probably want to try and limit the liability to just that one asset. I'm
Exactly.
just paraphrasing for the audience here.
Yeah. So for my own assets, I've got a parent LLC, and then each of our rental properties are in their own box as single member LLCs. Then I have an umbrella policy, and all of those things, even though I personally guarantee all of my mortgages, it at least provides extra layers of protection when outside things happen.
Yeah, you give multiple walls in your castle and moats and various things in there for protection, so that anybody, like somebody tries to sue you, then you've got all these little layers that keep them out. Yeah, that makes sense.
Yeah. But I always see the worst case scenarios. So
house blowing up. Yeah.
Yeah.
Well, I would think sometimes our borrowers will just go online and grab an LLC. So what's the difference between just structuring the LLC from an online template than coming to someone like you and helping out? What's the difference?
Yeah.
Like, kind of how can that help?
Frankly, you're paying a lawyer for an operating agreement. Anyone can go online and pay $100 and form an LLC, and they can go to, Google operating agreement. But, I like to quote Gary Keller from the Tim Ferriss show, the podcast that he did, where he calls contracts disagreements, because no one looks at them until there's a dispute. And, the lawyer, my job is to anticipate worst case scenarios and talk them through and put them in the document while we're all still friends. So that way, when things go wrong, we can look back at this document and say, oh yeah, we spoke about this, and this is what we're going to do now. And that way we don't have to go to court, and business doesn't have to stop, and everyone can keep moving on. And that's what a lawyer should provide you as opposed to just trying to do it yourself.
Got it. Great question.
Okay.
It's worth it to me. It's always be wishing you would have if you didn't do it in the beginning. So just do it right the first time, and then hopefully you'll never have to talk to you if something goes awry. So that's awesome.
Yes.
Great. And I see that there are definitely questions coming. We just have a couple more questions that maybe some of these might be answered with the questions that we have. So we're just going to keep going, but I promise you, we'll get to these questions soon. Okay. Awesome.
Yep. Okay. So I'm going to jump in with the next one here. Shawn, can you talk about the difference between a little more detail about the difference between a general partner and a limited partner, and what does that mean for that limited partner? What is their space, and what is the general partner space when they're together?
Yeah, so the general partner is going to be the one that's acting on behalf of the partnership, going to be the one conducting the day-to-day business, and the limited partner is going to be the silent investor, the one in the backseat, not making decisions, just kind of getting what should be passive benefits from the partnership.
Collecting checks.
Yeah, exactly. The general partners are the ones that are going to be personally liable for the obligations of the partnership, and limited partners will not be.
Cool.
Got it. Okay. What are common problems that you see in partnerships?
The common problems that I see in partnerships would be, the three big ones. And I'm going to talk about this one in our case study with a little bit more detail, but not properly structuring the management of the business in an effort to play nice or be inclusive, or in the name of fairness, sometimes creating more problems for yourself downstream. And we'll talk about that in more depth. So like I said, we're primarily dealing with LLCs in the real estate context, and they're either manager managed or member managed. And defining the roles of who's in charge of what, I think, is important on the front end. And that creates problems if it's not well defined. The other one is erosion of trust between partners. That usually results from a partner some lying, laziness, or leisure. So some distrust arises, books aren't quite right, or someone, is off in Cancun playing too hard, or, someone develops a drug problem, or a whole host of reasons that you see where things just don't go as planned. And then the third one, which we spoke about, is a failure to anticipate possible negative outcomes and have multiple exit strategies for a project.
Those like escape hatches where people can get out of this.
Yeah. I mean, you really need to just kind of take a shotgun approach to any project, and things don't always work out. And if it doesn't, what does that look like?
Yeah, absolutely. And I can only imagine, for me, I wouldn't think, oh, the house next door, burnt down and someone passed away. But since you've seen the horrible things happen, how to prevent and structure an LLC that would protect the individuals, versus if we just went and Googled and not even thinking stuff like that can happen. So that's a great thing to point out.
To the best of my ability, right? You can't anticipate every possible consequence, but these are things that we're thinking about.
Yep, 100%. Cool.
Let's shift gears for a minute. I want to take a couple of the audience questions, and let's see. I know Brian had one in here. What is the difference with an LLC with members that have an agreement that delineates ownership and risk in the operating agreement, and an LLP with the same operating agreement?
So the difference between an LLC and an LLP, it's just going to come down to personal liability, right? The members of an LLC are not going to be personally liable unless the person suing you pierces the corporate veil. With an LLP, there will be some vicarious liability depending on the set of circumstances, but there's going to be more possibility that there's vicarious liability for partnership obligations that arise from contract and tort claims. So, that the limited liability partnership doesn't pay their lease. If there isn't a personal guarantee in a limited liability partnership, the limited partners can still be sued individually. Does that make sense?
Oh. Yeah.
As opposed to an LLC, which would need the personal guarantee in order for the members to be sued personally.
Right.
Oh, so let's touch on that, because I think Carl asked that question. Is it true that the LLC only protects in an event, Opa just got passed, that it's a non-recourse loan? So in an LLC, are you protected if it's a non-recourse loan?
If it's a non-recourse loan, then
you can't.
Then it lives and dies with the LLC.
Got it. But what if it is a recourse loan?
Well, then, you're going to be sued personally.
Personal guarantee, and
right.
Even if the LLC fails, you're still on the hook. Yeah,
exactly.
Okay. So then, go ahead, Chris.
Well, I think
I'll Carl's other half of that. Moving on to piecing the corporate veil comment. This goes towards prior question on non-recourse. Is that a question, Carl? Or is that, I'm not sure.
What we can do too, Carl, at the very end with a Q&A, if you're comfortable, we would love for you to like come on. We can get you unmuted and we can get those questions answered for you. Oh, he's on. Woo! Okay, you have to unmute.
Yeah,
Yeah.
hi guys. Sorry, I just
Okay.
wanted to get more around that, and I was just sending this around the piercing of the corporate veil, because I mean, I understand that you sign a non-recourse and the banks can't come against you, but personal liability relative to, let's say, actions of tenants or what have you, is separate from non-recourse is only relative to the bank for the most part. So I get that piece. I'm looking at the other part, and when you mentioned piercing of the corporate veil, that's really where I was trying to get into, because as I understand it, is LLCs only, you know, it's a paper shield, right? So I mean, what's true in that, what's not, and you know, how do you strengthen that?
It is a paper shield. You're right. But an LLC is its own separate individual in the eyes of the law, and its members are not liable for the actions of the LLC so long as that shield stays intact. Things that pierce it are commingling of funds is a big one, and not keeping your corporate formalities. So, you know, if you agree to have you know, make a personal loan to the LLC, and you know, you want to have a consent in lieu of member meeting. You want to have some kind of formal documentation that establishes the transfer of funds between the members and the LLC, so that it's not looking like you're just using it as a slush fund or as a place to hide money or you know, this, that, and the other thing.
Okay, but so considering it's a sole, let's say a sole entity, right, sole proprietorship, and in that case, there's a number of properties, and you pull out income, as long as you document that income as source, that's fine.
Yeah, as long as you have proper corporate formalities, right? Like I said, not paying your Netflix out of
Yeah, I understand.
out of the LLC, not like having a car that's titled in your name, like not making car payments on that. If the car should be owned in the name of the LLC, if you're making car payments from the LLC, you know, if you have a lease that, you know, a business lease and your individual name is on the lease and you're paying from the LLC, that's a problem. Like these are, everything has to fit in its little box.
Okay.
Does that make sense, Carl?
Yeah. Appreciate it.
Shawn, what you're saying with that is that if somebody has an LLC, they should absolutely have a separate bank account for that LLC and only have things that like the loan they're doing with us, for example. If that's the only thing in the LLC, all payments in and out, disbursements and also money coming in and going out should all go through the LLC only, and nothing else should go through that account.
Absolutely. Like the rent, like your tenants should not be writing checks to you individually. If the property is owned by an LLC.
It should be to the LLC.
Exactly. Yeah. All of those things get you in a lot of trouble.
Well, that makes sense. So with our, we do have 30 years. We always make sure that the 30-year loan, the ownership is in the name of the LLC and the lease is in the name of the LLC, and the tenant writes the check to the LLC because that's who the landlord is in the lease agreement. And so yeah, this all matches up to protect the borrowers. Yeah.
Absolutely. Yeah. Brian had a really good question as why would you ever do an LLP over an LLC with the partners as a member with an OP?
Well, so an LLP, at least in Oregon, is only available to professionals. And the real estate investor is not going to fall under that purview. So really, it's not something that's available to someone that wants to, you know, do a flip or have a rental or something like that. It's really more thinking like, let's think group of doctors as an LLP. So it's not really relative to this conversation so much. So if we're talking about buying and selling dirt, rental properties, assets related to real estate, then you're really thinking about LLCs and tenants in common agreements.
Right. Okay. That's a great question. I think Ken was going to ask one of my next questions, which is what should we include in the terms of agreement? And what should every investor know? He wanted to know what are the do's and don'ts. So that's kind of a lot of questions all at once. If you want to try jumping in on that.
Okay, so what should we include in the terms of the agreement? Generally, an operating agreement is going to hit 5 things. The first one is the organizational information, the who, what, when, where, why, and how of the LLC. Then you're going to talk about the management of the entity. How is it conducting business? Third thing you're going to talk about is the money. How are profits and losses distributed? What does the flow of assets look like? You want to also address changes in membership and dissolution and winding up. So you want to the life cycle of an entity. The operating agreement should cover all of those things. What were the other questions?
What is something that every investor should know when they get started?
Oh boy.
We have a couple hours.
That you're going to make mistakes and that you should talk to people who have done this a lot more than you have. Building a solid team. And, my grandfather, he had a couple of rules that he lived by. One was never rush into a decision. And the other one was the only way you lose $1 million is by trying to make 2. So by small gains, not leaps and bounds, will usually make you make things better than end up bankrupt, frankly.
Yeah, we don't want that. That's not good.
Yeah.
No, that's not good. Do you have any, is there, besides just coming seeing you, do's or don'ts lists? I think that was one of his questions.
Okay. My overarching piece of advice that I give all of my clients when they come into my office is don't be an asshole. Just generally speaking, being reasonable will usually get you further in life than not. It's very rare that a tenant comes into a lawyer's office wanting to sue their reasonable landlord, or a lender wants to sue the reasonable borrower who comes to them when they're having problems. There's lots of different ways to get to a solution, and I try the path of least resistance first. So that would be my don't, and my do would be to reach out to people who have done it more than you have and listen.
Oh, that's awesome advice. You get anything out of this class, that's like an amazing advice right there.
Yeah.
Those nuggets right there. And I promise you at the end, we are going to give, he's going to plug his information. So I know, Brian, I will connect you guys. Like I know that there's more questions stewing. He has a case study for us. He has actually 2 that he's going to start the slideshow and go through. So we definitely will get to the questions as well.
Sure.
But perfect. We're getting this.
There you go.
Greta's sharing the screen. All right, talk to us
There we
about
go.
it.
So I wanted to present a case study that focuses on the importance of effective management. And I wanted to highlight that by talking about 2 commercial redevelopment projects that are similar, that had very different outcomes. The first project involved an LLC. A client came to me wanting to form an LLC so we could purchase a 2-story commercial building in 2019. It was a 100-year-old building and needed a lot of TLC, and he wanted to use it for office, retail, and Airbnb, and to headquarter his business. We set him up with an LLC, and I got his permission to talk about this case ahead of time, full disclosure.
Another disclaimer.
And we set him up with a member-managed LLC that had 2 members. He had a 50% interest in the business and was the one primarily running the project. And the other 50% was owned by an LLC that was made up of 2 couples that were from out of state, and they each had a 25% interest in it. The out-of-state couple didn't really do much on the day-to-day, but they provided some capital and some broad strategic oversight. But the operating agreement required a majority vote for the LLC to do anything. Well, that quickly became an issue when the 2 couples who had the other 50% got into a fight over money on a different project from another state and then stopped talking to each other. And that dispute basically paralyzed the Oregon LLC that was trying to do this commercial project, and it stopped the business. That became a huge problem because all of the members had personally guaranteed over $1 million in short-term debt. The costs of construction were ballooning, and the guy that was running the show, he needed to raise additional capital to refi. You needed to raise additional capital to finish the project and refi, or else he was going to default on his obligations, and he couldn't do anything. So the lawyers get involved. Like I said, they purchased the building in 2019. The dispute happened in May of 2020. The $1 million note was due the end of the year, this past December. And it took us from May to December 14th to reach a resolution. And the resolution was that the couples transferred him one membership unit to break the deadlock, to allow him to keep moving forward on the project. And then he bought them out when he was able to complete the refi. And so for me, the takeaway from that project was that in trying to strive for equity between the partners, it ultimately led to paralysis for the business. And the project stalled for no good reason whatsoever. It had nothing to do with the business, had nothing to do with the operation of the business, it just had to do with personalities from something else that ended up wasting time, money, and strained their relationships with their lenders who were loaning them a significant sum of money. And, as it sits here today, that project is still in design review with the city of Portland, and they had to partition the lot and sell off half of the parcel in order to recoup some of the losses, which their plan was to develop the entire thing. So that's kind of the member managed horror story that I helped him kind of find a way out of. And I learned a lot from it. And then the second case study to contrast is my own building. Actually, I recently in 2019, we purchased this property in Southeast Portland, same size building, needed the same amount of TLC, 2-story, 100-year-old building. With our goal was to turn it into office and retail. And there was an existing apartment that we converted into more office and used it to headquarter our businesses. So I got a group of 4 small business owners that live and work in the neighborhood, myself included, and I formed an LLC for us to buy this building. But I formed a manager-managed LLC as opposed to a member-managed LLC, naming myself as the manager. So despite having a minority share in the entity, I was able and am still able to make unilateral decisions on behalf of the company. Purchased the building at the same time, COVID happened. We had all personally guaranteed over $1 million in short-term debt. The cost of construction started ballooning pretty quickly. We needed to raise additional capital and refi. We were facing some pretty, daunting circumstances, and that created a lot of conflict between me and my business partners. A lot of second guessing about how we get to this. I'm sure we're all familiar where you start with a pro forma, at acquisition, and 6 months later things look drastically different when you're down to the studs. So the big difference is that everyone had given me authority to run the show before we started fighting with each other. And this allowed us it prevented deadlocks, and it allowed the business to keep moving forward. So the result was that we were able to finish the project in a year, although we were grossly over budget. I was able to secure short-term debt, which we then refinanced into a permanent loan after we got our certificate of occupancy. Unfortunately, our 5-year recapitalization plan turned into a 10-year plan, but at least I'm sitting in my own building paying myself rent as opposed to still sitting in design review like my client's LLC. So those are the takeaways, that it's really important to get the structural integrity and the decision making on the front end before problems arise. And if you are going to do a 50-50 LLC. I really try and advise my clients against a 50-50 LLC. I know that a lot of times people want the equity, but if you are going to do that, you should, and I think we can go to the next slide. So this is before and after. Okay, well, yeah, this is before and after of my building. The picture on the left, the top and the bottom, is the before and after of the retail space, and the picture on the right is the before and after of my office that I'm sitting in right now.
It's like
So,
we all love before and afters.
Right?
Everybody in this whole Zoom love before and afters. Doesn't matter
Oh,
what
yeah.
it is.
The one on the left was actually an art studio, which was a guy living in the building. And then the one on the right was a quote unquote production company where they were just growing a bunch of weed up here. It was the primary uses of the building. So if you go to the next, the major differences is that I expressed, just the management and being able, not having to hold everyone's hand and give everyone an equal say, allowed us to get to the completion. But if you are going to do that, and there are times where you have to do it, you should really build into your operating agreement some informal process that allows you to break a deadlock before you have to get a lawyer involved. And the examples that I have employed myself, my first suggestion is to get a third-party person that both members trust and isn't involved in the project, but they respect their advice. Let that person make a decision if you guys are deadlocked. You might, kick them some cash or whatever, whatever you got to do to get them on board for this. But just let them be the tiebreaker. I've seen rock, paper, scissors. I've seen, rolling dice, high card, coin toss, whatever it is, write it in there. And, if someone still decides to sue, then that's their right. But at least, you've tried to put some internal dispute resolution mechanism in there so that you don't have to stall your project for 6 months while you pay lawyers a bunch of money to fix a mess that you should have been able to fix on your own.
Yeah.
Love it, man. I love that you explain this, man, because I mean, so many times people are like, I'm not an attorney, here's the sample document,
Yeah.
and off it goes, and people have no clue where to even start. And I also love that this is like your primary focus. I mean, I think we all know attorneys here that kind of do a little bit of everything, but I love this is like something that you do, not only for like, that's your client focus, but also you've done for yourself. So that's awesome.
Yeah, I think the fact that I have my own investments and that I have been the one to apply for commercial loans and have had to jump through those hoops, and I signed my own personal guarantees. It gives me, I have seen my pro forma creep out of control. Like it gives me a different perspective to be able to sympathize with my clients and then I spent the first 5 years of my career in the courtroom, and I know there's things that are worth fighting over, right? There are certain things that are worth going to court and having your day in court and looking for justice in the court system to help you. 9 times out of 10, being a landlord is not where you want to be, especially in the city of Portland. Or, we're greedy real estate investors, right? I mean, it's just not like you're not looked upon favorably in the justice system. This isn't the fight worth fighting in that sphere, in my opinion.
So true, especially in the state of Washington as well. We're getting really close to, I promised 15 minutes. I know people are asking questions, so we want to jump on as well, because we definitely want to just kind of wrap this up and get the last Q&A questions. Shawn, do you have any last moment things or plugs for your business of how you can help all of us? I know some of us are in Washington, but I know that you are in other states like Nevada. If you want to set an LLC in Nevada, you can help. So it doesn't matter that we're actually living in Washington. Can you tell us a little bit more about that?
Basically, my job is to help people solve their real estate problems. So feel free to give me a call, 503-498-8528. Send me an email. And, I offer flat fee options for entity issues. And then if it's litigation work or landlord tenant work, it's more hourly. And we can, I offer a free 15-minute consultation, and then we can explore your issues and find some solutions.
Awesome. That's great. Awesome. let's see here. Everyone also know that we have a Facebook group that is just specifically for our Chris and I's classes. We've been doing this for a long time, and we finally decided to put a platform for all of us to help. So if you're interested in that, we will definitely, with the follow-up email, we'll send you a link so you can join us, get lots of questions answered, or just help each other out. So definitely look for that. Look for, at the end, there's going to be a survey that says, hey, what did you like? What can we do better? What classes do you want? So definitely answer those, because that's how we get your next class and how we can continue to be helpful to you guys as well. Chris, do you want to add anything to that?
Yeah, I would just say, like, in that capitalized Facebook group, guys, that's also where we post our classes and things that are coming up. I think I'm making a mental note already to put Shawn's information in there as a definitely a resource for all of us in the space of real estate, setting up in these structures. And it's amazing hour today. So that was
Absolutely.
awesome. And then also, you guys, Lesa and I, we both do a ton of business with Rain City Capital, and we're looking at all kinds of deals all the time. And we see a lot of these structures come through. And so if you guys would want to talk through a deal or talk through a structure, we'll try and help as best we can. Obviously, we're not attorneys either, so we're not going to, advise that way. We can say, hey, this is what I've seen in the past. This is this, and then it gets kind of heavy. Then, call somebody like Shawn or call a CPA for this or that. But yeah, you guys, this is an ongoing resource for all of you. That we just want to be a benefit. And Rain City Capital, we do all kinds of lending, you guys. We do the fix and flip, the new construction we were talking about. We do land development. We do 30-year fixed. We're trying to increase your portfolio and have those 20 LLCs with one master LLC. We can do all the loans on all those properties, or one big wrap loan. So there's all kinds of different options that we can help out with. And yeah, we're just thrilled to be able to serve and help you guys today.
Absolutely. Thank you so much, Shawn, for taking your time with us. I really appreciate it.
Oh, it was my absolute pleasure. Thank you so much for the opportunity, and look forward to being on anytime you guys need to talk more about legal stuff.
All right, guys. Well, thank you so much, everybody. I appreciate it.
Okay, take care.
Thanks.
Thank you.
Bye.